everyone, welcome back to Litigation Help. My name is Hui-Litwin, and this video is a continuation of our video series, which compares the legal rights and obligations between legally married and cohabiting couples in Canada. If you have not watched our previous videos, you can click on the link above and watch them. But today, in this video, we're just going to focus on Ontario law. So joining me once again is Helena Birt. Hi, Helena.
Hey, Heather, how are you?
Great. Okay, so Helena, let's start with property rights. So Helena, you mentioned in the previous video that legally married couples have rights when it comes to property division upon separation. Maybe could you elaborate a little bit more on what you mean by that?
Right, that is probably one of the major differences in Ontario between being married and then separating and living in a common law relationship and separating. If you are married, the Family Law Act sets out a whole legislated regime about how you deal with the division of property or the value of property that accumulated during the marriage in the event of a marriage breakdown. And those rules, and it's called an equalization of net family property, it only applies to couples that are married. It does not apply to couples who are in cohabiting or in what's called a common law relationship.
Okay, so now I'm going to ask you a few sort of more specific topics. So some people have asked inheritance from a family, for example, how is that treated? How is that is it different between the legally married versus the common law, or I should say cohabitation?
Inheritances are property.
Right.
So it could be an actual specific piece of property, like a chair or a house.
Right.
Unless it's a matrimonial home, which gets really kind of crazy down the road. Right. But if it's a property like that, like a house or something tangible, then and it comes to a person by way of a gift or an inheritance from a third party, like it doesn't count if it's a present or a gift from the other spouse. You can have that, or it could be like a bequest that you get through a will, where it's a quantity of money that comes in. And then, so you've got the inheritance, which is a monetary cash value. And if you are married, the value of any inheritances that are received during the course of the marriage under the Family Law Act are excluded from that spouse's net family property. So if you received something by way of gift or an inheritance, it's yours and it belongs to you, and the other party doesn't have any claim to it. Unless you've done something like, for example, if you've got a monetary bequest, if you received that bequest and you put it into a joint bank account with your spouse, by putting it in the joint bank account, you're acknowledging that that's an asset that you're sharing 50-50 in. So again, it's really, really important for people to think about what they're going to be doing with things. If you took that same inheritance and you invested it into an RRSP or another mutual funds or GIC that is only in your name, then the value of that GIC and any increases in the value of it will remain excluded from your net family property. But if you meld it into family property that you're sharing with the other spouse, you could lose that exemption. But the basic general rule is any gift or inheritance received from a third party during the course of the marriage belongs to the person to whom that gift was given to.
So if you're just cohabiting with your partner and you receive an inheritance, then obviously they don't have an entitlement to it.
Yeah, and I think we're going to go back and visit this a couple of times because it's probably one of the most important things to remember, that in Ontario, and this is not necessarily the case in other provinces, like JP talks about that in his videos as well, because the property rules do vary from province to province. But in Ontario, if you are in a common law relationship or cohabiting without getting married, you do not have any legislated rights to property. As far as the Family Law Act is concerned, you're not a spouse for the purposes of a division of property. So what that means is that if you're not married and you're living with somebody and the relationship breaks down and you separate, it's just the same as if you've been living with a platonic roommate, no matter how long you've been together. Each of you takes away what you brought into the relationship. If anything was purchased during the relationship, it's whoever can prove they bought and paid for it gets to take it with them. There's nothing in the law that says otherwise. Now, and again, I think we will get in later about saying that just because you're in a common law relationship doesn't mean you might be completely shut out, but it's just that there is nothing in the legislation that gives you a right to claim property that's owned by the other person. just keep in mind, the general starting point is just the same as if you're living with somebody as a platonic roommate and you no longer live together. How are you going to split up your stuff? It's done on the basis of who can prove they paid for what.